Hello, my name is Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. In a recent case concerning a failed IT system, the Court of Appeal, overturning the High Court decision, ruled that the claimant, Soteria Insurance, was entitled to claim its wasted expenditure of implementing the system from the supplier, IBM. Now, IBM had refused to pay because the contract excluded liability for loss of profits, but the court decided that wasted expenditure is not the same as loss of profits and therefore was not excluded by the contract. In the judgment, the court explained that if a party wants to exclude a valuable right, exclusion of wasted costs in this case, the language must be clear, and there was no express exclusion of wasted costs in this instance. The FCA has finalised rules requiring listed companies to report information and disclose against targets on the representation of women and ethnic minorities on their boards and executive management. Companies will be required to make the new disclosures in their annual reports for financial years starting on or after April of this year. Client Earth, a shareholder of Shell, has taken the first steps to issue a claim against Shell's directors for failing to manage climate risk as required by the Companies Act. Section 1721D requires a director, in discharging its duties, to have specific regard to the impact of the company's operations on the community and the environment. Now, if this claim is successful, the court could force Shell to revise its net zero transition strategy and may find that its directors have acted in breach of their statutory duties. The government has brought forward the implementation of the Economic Crime, Transparency and Enforcement Act of 2022, which received royal assent on the 15th of March, bringing in the register of overseas entities that own UK property. The law will require overseas companies or similar entities that are registered proprietors of UK residential or commercial property to investigate and provide details of their beneficial owners or the individuals who control them to UK Companies House. The information will appear on a register that is publicly accessible. It is not yet clear when the provisions setting up the register will come into force, but we expect this to happen once Companies House and the Land Registry have set up the necessary systems to deliver the Act's requirements. Google has announced the completion of the full redesign of its cookie consent practices. Under this new practice, users will see a new cookie consent choice window with equal, reject all and accept all buttons on the first screen. The revised practice follows the €150 million cookie-related fine issued by the French data regulator CNIL to Google at the end of 2021 because of Google's failure to make it as easy for French users to reject all cookies as it was to accept them. The UK data regulator, the ICO, has issued a statement welcoming this action by Google and commenting, "We expect to see the industry following Google's lead to provide clearer choices for consumers." The Court of Appeal has ruled that an employer acted lawfully by accessing an email account used by a former employee who was under investigation. The court decided that the employee could not have had any expectation of privacy as it was an inquiries email account for event bookings and accessed by other staff. But even if there had been a reasonable expectation of privacy, the defendants had only disclosed the emails to their professional advisors, a trustee in bankruptcy, and to another business associate, which did not amount to a breach of privacy. A law firm has been fined following a ransomware attack. The fine was small, £98,000, so not likely to make any headlines, but the ICO's penalty notice contains some helpful pointers that show the minimum expectations on any organisation to meet their security obligations. First, multi-factor authentication, a relatively low-cost security measure to require 2 or more verification measures to access an account. Next, patch it up. The law firm had waited more than 4 months after a software patch was released before installing it, despite the patch being widely publicised and free. And finally, encryption. Following some high-profile instances of fire and rehire, where an employer dismisses a worker and then re-engages them on less favourable terms, the government has announced a new statutory code on the practice which details how employers should hold fair, transparent and meaningful consultations on proposed changes to terms of employment. Courts and employment tribunals will take the code into account when considering cases, and an unreasonable failure to comply with the code may increase compensation for each employee by 25%. A lawyer, Ms Long, who was engaged by British Gas, has won a claim for discrimination and unfair dismissal. Ms Long had returned to work after her maternity leave on a part-time job share contract, but when the job share partner left, Ms Long felt she was put under pressure to work outside her contracted hours. The tribunal saw evidence of this in emails between her line managers, which referred to telling her that work does not stop at the end of her contracted hours. In 2019, Ms Long was told that she'd been put on a performance improvement plan and at the risk of redundancy. In the scoring matrix, Ms Long had scored 1 out of 7 for focus, but the tribunal found that the score was irrational, as her line manager told the tribunal that Long's focus was good in respect to the lion's share of her work. To make matters worse for British Gas, it was unable to justify why her male colleague was paid £2,000 a year more than her. Following the relaxation of government measures under its plan for living with COVID, the onus is on employers to assess and manage COVID safely through internal policies. The UK Health Security Agency has published revised guidance for reducing the spread of respiratory infections, including COVID-19 in the workplace. Since the 6th of April, employers have been required to use the Home Office's digital right to work check service for employees who hold a biometric residence card, a biometric residence permit or a frontier worker permit. For other employees, the end date for the temporary adjustments to right to work checks has been pushed back from the 5th of April to the 30th of September. The UK government has announced sweeping reforms to UK consumer protection rules. These include new powers for the Competition and Markets Authority, the CMA, to impose large fines of up to 10% of global turnover and to order consumer compensation. Aside from these financial measures, the government says that it wants to grant the CMA stronger powers for direct enforcement of investigations and fines without requiring the CMA to go through the courts. To enable all public consumer enforcers to apply to the civil courts to impose financial penalties for consumer law breaches. To support consumers and traders to resolve more disputes independently, particularly by encouraging the uptake of alternative dispute resolution services. There are some specific concerns that the new laws will also address. Tackling the so-called subscription traps by requiring clearer information and mandating auto-renew reminders. Addressing fake reviews online, hosting reviews without taking reasonable and proportionate steps to check that they are genuine will be illegal. And strengthening prepayment protections. We now await the publications of the government's draft legislation to build out the detail of these proposals. That's it for this month. Thank you for tuning in. We've included the links to all of the documents we referred to today in a written version of this bulletin, but please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.